It's time for Preserving Your Dignity and Your Money, Planning for Successful Aging with Nugen Law. And now your host, J. Bryan Nugen, estate planning and elder law attorney.
Good morning, and welcome to Preserving Your Dignity and Your Money, Planning for Successful Aging with Nugen Law. I'm Attorney J. Bryan Nugen, founder of Nugen Law and your host for our program. The purpose of our show is to have weekly, in-depth conversations about matters relevant to folks as they walk down the path of successful aging. Our listeners will learn what it is to age with dignity and how best to protect their money. I've been practicing law for 3 decades. I'm licensed to practice in Indiana, Ohio, Michigan, and Florida, and actively represent clients in all 4 states. My practice, the attorneys, and our interdisciplinary team of professionals who practice with me concentrate on working with clients in estate planning and elder law and areas related to them, such as protecting money from nursing home stays, securing benefits from programs like Medicaid and the VA, geriatric care coordination, estate and trust administration, guardianships, and planning for those with special needs. Nugen Law clients in many stages of life. Nugen Law rather sees clients in many stages of life, but commonly we have folks reaching out when they or a loved one are showing signs of needing help. Those signs may include a chronic ailment or progressive decline before, during, or after a hospitalization. In instances of incapacity, caregiver burnout, stress on family members due to some or all of those instances I just mentioned. As a reminder, Nugen Law represents clients in Indiana, Ohio, Michigan, and Florida. If you hear something in today's broadcast which resonates with you, an area in which we may be able to help, please call Nugen Law at 260-925-3738, speak with one of our intake specialists, and schedule a meeting for either our Fort Wayne or Auburn locations. You're also encouraged to see us online at www.nugenlaw, that's NUGENLAW.com. To our listeners, Nugen Law will be presenting a free seminar on August 15th between 1 and 5 p.m. In Fort Wayne, with a deeper dive into how you can be sure to preserve your dignity and protect your money, with topics like asset preservation, care management as you age, estate planning, and elder law. Please call us at 260-925-3738 to reserve your spot for that August 15th event between 1 and 5 here in Fort Wayne. Today, I have a member of the Nugen Law interdisciplinary team, Attorney Jesslyn Smith, here in the studio. Jesslyn is licensed to practice law in Indiana, has been doing so in excess of a decade, and is currently serving as president of Indiana's chapter of the National Academy of Elder Law Attorneys. Very impressive, Jesslyn. Welcome to Preserving Your Dignity and Your Money, Planning for Successful Aging with Nugen Law. Jesslyn, please start by letting our listeners know what brought you to the practice of law and, more importantly, estate planning and elder law.
Yeah, thank you, Bryan.
Yeah,
I decided when I was 11 years old that I wanted to become an attorney. My mom got an attorney for the first time that I remember, and absolutely fell in love with that attorney and knew I wanted to help people in that role. But then I went to undergrad, and I realized I wanted to figure out what type of law that I wanted to practice, and so I worked at a couple of different firms as a paralegal to figure out what that next step would be for me. And I started working for an elder law firm and fell in love with the area of elder law and estate planning. And that was when I decided to go back to law school. And so I went back to law school while I worked. And so that was quite an experience in itself, working and juggling.
I respect that, if you can get successfully through law school while you're working full-time, that is dedication. And what it should tell you, it's a compliment to you, Jesslyn, and should tell our listeners as well, is that you really did have a passion for it, because it's hard work. It's tough to be in school even when you're not working, but then to put work on top of it and then finally, for you to be as successful as you've been, it's a huge compliment to you.
Thank you.
Yep.
And so, I've been practicing now 11 years as an attorney, and I keep finding new ways that I love the area of estate planning and elder law.
Nice. Well, I know personally one area of elder law for which you have a great deal of passion is the care of our clients with special needs. So let's begin by having you define generally what it means when someone is recognized as having special needs.
Yeah, someone with special needs is someone that has a disease or a condition in which they need some kind of assistance and likely receiving some type of public benefits. And so because they have those special needs, they have particular rules that they need to follow. And we have tools that we can use in order to help them continue to live and manage their life while they have that condition.
And the condition could be temporary, could be permanent. If they're recognized as being special needs at that time, that's what we're looking at. What is it that why is it that we must pay attention to how we manage the funds of those with special needs? What happens if they have immediate access to their money, for example?
Well, if they have immediate access to that money, their public benefits programs say you have enough money then to live off of, and so we're not going to help take care of you. When in reality, if they're using those funds that they've received or the funds that they do have in that special needs trust, they can go through that money very quickly to take care of those needs, and that's why they need the public benefits.
You're getting ahead of me. You mentioned something, special needs trust. So I'm going to ask what types of instruments are you preparing for your special needs clients at Nugen Law? So special needs trusts, obviously.
Correct, yeah. And there's several different types of special needs trusts that we talk about. There are first-party special needs trust, and there are third-party special needs trust.
So let's break that down.
Yeah.
First-party special needs trust. Where's the money come from when we're creating those?
That comes directly from the beneficiary, the one that is receiving the public benefits. And so they're using funds that they've had or funds that they're going to receive, maybe through a settlement or something.
Right.
And so they take those funds that are theirs to fund that first-party special needs trust.
So a recent example in the office at Nugen Law was another law firm that pretty much just does personal injury matters had reached out to us for us to prepare special needs trust for their client, who then became our client. So when that settlement happened from that accident, their funds were able to be poured into the special needs, for in this instance, first person special needs trust. So the money came from them. They put the money into the trust for their benefit. And then break it down for just a little bit more, Jesslyn. So once the money is in this instance, from that personal injury settlement, we have money in the special needs trust. Is there any impact then on any of the public benefits that they may be receiving if that trust is properly managed?
If it's properly managed, no, they can continue to receive their public benefits.
All right. And the person that's managing it would be called a trustee. And that could be a family member. It also could be a professional trust department. But it couldn't be the person that created the trust.
Correct, because then they would have the actual control and access directly to those funds. And so the beneficiary themselves cannot serve in that role as the trustee.
I look at those special needs trusts as it's giving you things that governmental programs couldn't give you. So if there's a little something extra that you need, that you have a resource. And then taking that special needs trust to its final conclusion, if the person that's the beneficiary of that trust that has the special needs, if they pass, the funds in that special needs trust, where do they go?
They go back to the state to reimburse the state for any benefits that they did pay out for them.
Okay.
And so that's a big distinction with that trust versus the third-party special needs trust. Because that first-party special needs trust requires that language to be in there that the state is the primary beneficiary first.
So if we have listeners, though, that are grandparents or parents of a special needs grandchild or child, and they're wanting to remember them, they shouldn't be concerned about the money going back to the state when the grandchild passes because they're a third party. So someone other than the individual with the special needs trust can create a trust for that person's benefit, and at their passing then, where do the funds go?
The funds go into that third-party special needs trust, and they are considered the grantor of that trust since it is their funds that are funding it, that parent, grandparent, sibling. So once they pass, their estate or the share that beneficiary would have received goes into that third-party special needs trust for that special needs individual.
Mm-hmm. And then when that special needs individual, when their life is complete and they've passed away, in this instance, do the funds go back to the state to reimburse the programs that individual is receiving benefits from during their lifetime?
No.
Okay.
So with the third-party special needs trust, there is not the requirement for the state to be named as beneficiary. And so with that, then the grantor, the grandparent, parents, they can decide where they want those funds to go after the beneficiary passes.
Excellent. To our listeners, Nugen Law will be presenting a free seminar on August 15th between 1 and 5 p.m. in Fort Wayne with a deeper dive into how you can be sure to preserve your dignity and protect your money with topics like asset preservation, care management as you age, estate planning, and elder law. So please give us a call, 260-925-3738 to reserve your spot for this free presentation. It should be very interesting. Jesslyn, let's talk just a little bit. I've heard you throw a few things around, terms around, and you and I know we use those on a daily basis. Some of our listeners may not. Grantor, trustee, beneficiary. What are those positions and what's their responsibility?
Yeah, the grantor simply means the person that is establishing or creating the trust. Mm-hmm. The trustee is the person that is in charge of managing and handling the funds that are held within the trust.
Right.
And then the beneficiary is, there's two types of beneficiaries. There's the lifetime beneficiary who can receive the funds while they're alive, and then who receives the funds after they die, the death beneficiaries.
Mm-hmm. Yeah, I like to use the phrase ultimate beneficiary.
Yeah.
It's much more pleasant than death beneficiary, but that's true. Yeah. So during the lifetime, for example, for the first party special needs trust, during the lifetime, the person with the special needs is the lifetime beneficiary. When they pass, the money goes to the state. They're the secondary or the ultimate beneficiary when they've passed to reimburse the state. On those third party special needs trusts, the person with the special needs gets the benefits during their lifetime. They're the beneficiary, lifetime beneficiary. And then it would go to whomever established the trust, whoever they're indicating it should go to. It could go to other children, grandchildren, charities, etc. That's the ultimate or death beneficiary. So if someone agrees to serve as a trustee, are they personally responsible for the debts of the beneficiary, the special needs person? Do they have to personally pay income taxes for the income generated by the trust? How does that work?
No, they're not personally liable. The trust usually has a separate EIN, or it uses
EIN,
the
employer
identification number or tax identification number.
Like our Social Security numbers, but the trust has a separate legal tax ID.
number, that identifies it, and then the trust is responsible for those expenses, those debts, and things that the beneficiary may have that are outside of the scope of what the public benefits are paying.
Mm-hmm. What responsibilities would the trustee have to the beneficiary of the trust?
Well, the trustee has a responsibility to manage those funds in an appropriate way. They can't waste the funds. And so they have to be careful about how they are utilizing the funds, because you also want to make sure there are enough funds there for the beneficiary too through their life. Now, that doesn't mean if there is something big that the beneficiary may need that they can't do it, but they have to evaluate the entire situation and make sure that they're not just wasting those funds.
They have a duty, a fiduciary duty.
Fiduciary duty, yes.
Yeah. And fiduciary is a very high standard where you're not looking out for your best interest whatsoever. You're looking out for the best interest of the beneficiary of that trust and making sure that money is invested wisely and the money is used appropriately. And just because someone is saying, I want something, doesn't necessarily mean I'm going to write a check and quickly deplete the funds. It's almost parental in nature, that you're watching the situation, making sure the funds are used appropriately and not misapplied, and ultimately for the benefit of the special needs person who may or may not recognize the need of maintaining those assets for their lifetime. So
Correct.
You can't spend it too quickly. That's
Yes.
always a challenge.
Yes.
As a reminder, Nugen Law represents clients in Indiana, Ohio, Michigan, and Florida. If you hear something in today's broadcast which resonates with you, an area in which we may be able to help, please call Nugen Law at 260-925-3738. Speak with one of our intake specialists and schedule a meeting for either our Fort Wayne or Auburn locations. You are also encouraged to see us online at www.nugenlaw, that's NUGENLAW.com. Next, Nugen Law will be presenting a free seminar on August 15th between 1 p.m. and 5 p.m. in Fort Wayne, taking a deeper dive into how you can be sure to preserve your dignity and protect your money, with topics like asset preservation, securing benefits to pay for your care as you age, care management as you age, estate planning, and elder law. Please give us a call, 925, that's area code 260-925-3738, to reserve your spot. Jesslyn, let's continue our discussion. I want to discuss something which could be related to special needs clients, not always, but could be, guardianships. Guardianships, what are they? When are they appropriate? And how do they work?
Yeah, guardianships are a way to appoint someone to be in charge of managing finances or healthcare decisions for someone who is incapacitated. And the process of that requires you to go to court, and the court legally finding, usually it's an adult that's incapacitated, that they need someone to be able to step in their shoes to manage finances or their healthcare decisions.
When are you typically approached by clients at Nugen Law about establishing a guardianship? For what reasons? Yeah,
there's a couple of different reasons. One common one that we see is when there is a special needs child that is turning 18, because legally in Indiana, once you turn 18, you are in charge of yourself, free to make your decisions. And sometimes those special needs children still need some guidance and help with managing finances and healthcare decisions by their parents. And so a lot of times we'll have parents coming in to ask us to establish a guardianship so that they can still help their special needs child making those decisions once they turn 18. And then the second common time we see them coming in is when someone is elderly and they are starting to have some diminished capacity and struggling with making their decisions or managing those finances, and they don't quite understand the importance of a power of attorney or a healthcare representative, and we really can't put those in place now because they are too far in their incapacity. And so then the children are coming in and saying we need to get guardianship over mom or dad or grandparents and taking care of their situation.
Excellent. Are medical experts consulted?
Yes, we usually give a form to the client to have the physician prepare a report to state what those incapacities are, so that we can present that evidence to the court.
Mm-hmm. What is the process to establish a guardianship, and does it differ for children versus adults? What's the process?
No, the process is the same, but we start off with the initial paperwork and establishing that our client, who's going to be the proposed guardian, we file a petition with the court along with an order and a notice of hearing and notices that have to go out to anybody that would have an interest in maybe potentially becoming the guardian of the incapacitated adult. Mm-hmm. And statutorily, we have a list or a priority of who those individuals are that we need to give notice to. And so we prepare that initial paperwork, the client signs it, and we file it with the court. The court then schedules it for hearing. There is always a hearing that we have in this process because the court needs to have that proposed guardian come before them to make sure that they actually qualify as a guardian. And then they also want to make sure and receive evidence that the person you're trying to get guardianship over is really, truly incapacitated, because the state doesn't like to take individuals' rights away. They always want you to be able to make those decisions on your own.
There's guardian ad litem. We haven't spoken about the role of guardian ad litem in the guardianship process. What is the GAL? What is the guardian ad litem?
So the guardian ad litem is a neutral third party that the court appoints and says, help us make this decision and make sure that who's trying to apply for guardianship is suitable and that the individual that is incapacitated is truly incapacitated. So that neutral third party is supposed to be the eyes and the ears for the court and investigate it before the hearing. And then at the hearing, the guardian ad litem usually submits a report to the court on what their findings were and if they believe this individual actually needs to have a guardianship in place.
Excellent. To our listeners, if the discussion of special needs matters and guardianships resonates with you and you would like to meet with Jesslyn or another one of the team members at Nugen Law, please call us at 260-925-3738 or send a message to us through our website, www.nugenlaw.com. You also can send us an email at help@nugenlaw.com, help@nugenlaw.com. After the court believes it's appropriate for the person to be the subject of a guardianship and a guardianship is established, what's the ongoing process thereafter, Jesslyn?
Yeah, so then the guardian who's been appointed by the court has a duty to the court to establish what does this incapacitated adult have with regard to assets. Mm-hmm. So we start with what's called an inventory. And so we have to account for everything that they own because the court wants to make sure that someone's not being taken advantage of. So they want that baseline of where that's at. And then following the inventory, then every 2 years, the guardian has to submit an accounting to the court and say, this is what we did with the funds and this is what they still have, and how we've been managing it. And so it's a report to the court to show those transactions that have occurred over the last 2 years.
And really to make sure that the person that's the subject of the guardianship isn't being taken advantage of, their money is being properly managed, that the trustee, the person managing it, is doing a good job. That's really the purpose of that ongoing.
It really is. It's a protection because if that person is incapacitated, they're not going to know and maybe be able to recognize that they're being taken advantage of. I like to explain to clients it's kind of a microscope then for the court to be able to see what is going on with that. And in a way, it does serve as having a greater protection than a POA in that sense. Because with the POA, you do still have the ability to manage and handle your assets yourself. but the POA isn't necessarily under that microscope. You can ask for an accounting of what they're doing, but it's not like they have to do it consistently every 2 years,
when you
like a guardianship.
Use the acronym POA, so power of attorney. So an individual has the ability, so long as they're competent, which is defined kind of uniquely, actually, when you're the individual, their competency in order to sign a power of attorney. But you're entering into an agreement that's permitting someone else to make financial decisions on your behalf. They can sign checks on your behalf and do those types of things on your behalf to obviate or circumvent the need for a guardianship, which generally POAs are what are in place and not guardianships.
Correct.
Yeah.
Yeah, and we prefer to use POAs. And really, within the guardianship, one of the requirements is we have to show that we explored the option of doing power of attorney documents because, again, the state doesn't like to take individuals' rights away, and so we have to show that there was a least restrictive mean considered before we actually tried to file that guardianship.
You mentioned earlier about consulting with the doctor, the guardian ad litem, making a report to the court. Do they have an ongoing engagement in the guardianship after the initial reports are made?
Usually not. However, the incapacitated adult, because if it was a temporary incapacity, they may try to petition the court later on to have the guardianship removed, and so they may need medical evidence again in order to have that established with the court that the guardianship can be terminated. So, but it's usually not ongoing. But, sometimes the doctor may need to present another report to the court. And usually the guardian ad litem's role is done after that initial hearing and establishing if there should be one in place.
We've heard horror stories in the news, right, about people being placed in a guardianship who may not really need one or may be on the edge, and their life was significantly altered as a result of the guardianship. How is it that the courts avoid establishing a guardianship for someone who may not really be appropriate for one?
Well, they avoid it by having those doctor reports and the guardian ad litem report. It's and that's why we have those positions or those roles that are important within the guardianship. It's not they just come in and we're going to make this decision, yes or no. There's a guardian. The court really wants us to have that evidence to show this is what needs to be established. And so sometimes those horror stories, there's underlying factors or facts that you may not know, too, with that situation. And again, it could have been something that was established temporarily, and now it just needs to be terminated if the individual's no longer incapacitated. But it's not normal for it to be that way.
We mentioned a few moments ago about durable powers of attorney. Are there some other instruments that somebody should consider having signed while they have the capacity to do so to avoid the guardianship if their capacity diminishes over time? What else, aside from a power of attorney, can you think that someone might consider having in place?
A healthcare representative form and a last will and testament or a trust. But the healthcare representative form is going to establish who can make a medical decision for you, which is separate from your finances, and who that person would be. And the healthcare representative form does not, it's not triggered until a doctor says you're unable to make your own healthcare decision. You're always able to make your own healthcare decision as long as the doctor says you can.
Sure. I do think that sometimes clients have the concern that, I shouldn't say think, clients have expressed to me a concern that if I sign that healthcare representative designation, if I sign that HIPAA waiver, in essence, they're equating that with a guardianship and thinking that they don't have control over things. And that's actually exactly the opposite. So long as you're competent, you can revoke that at any time. You're not giving up anything. If you are competent, those healthcare rep designations only come into play when you're in a position where you can't make a healthcare decision for yourself. You're always in charge of your own destiny, so long as you have some level of competence. How often is it that you're finding yourself preparing powers of attorney, healthcare reps, et cetera, for your clients?
Every day.
Yeah.
We usually have clients in every day asking for us to have those documents prepared for them.
I think yesterday I signed 3 or 4 with different clients. These are basic things that everybody should have in place.
Absolutely.
As a reminder, Nugen Law represents clients in Indiana, Ohio, Michigan, and Florida. If you hear something in today's broadcast that resonates with you in an area which we may be able to help, please give us a call, 925-3738. Thank you for listening to Preserving Your Dignity and Your Money, Planning for Successful Aging with Nugen Law. Look forward to speaking with you next weekend. Take care.
You've been listening to Preserving Your Dignity and Your Money, Planning for Successful Aging with Nugen Law. For more information, log on to NugenLaw.com or email help@NugenLaw.com. Nothing stated in today's program should be considered as legal advice, should not be considered as having created an attorney-client relationship between show host and guests and any listener. Nugen Law is not liable for anything that happens as a result of a listener relying on provided information as legal advice. The content is for informational purposes only.